This is advocate number 7, and we're discussing the switch from civil jurisdiction to criminal jurisdiction and the laws which permit that. So I've got the Criminal Law Act 1967, section 4, which says that the penalties for assisting offenders, which is that where a person has committed a relevant offence, any other person who, knowing or believing him to be guilty of the offence or of some other relevant offence, does without lawful authority or reasonable excuse any act with intent to impede his apprehension or prosecution shall be guilty of an offence. So I'm going to just read the criminal jurisdiction of the Criminal Appeals Court of the 369 Lloyds Banking Group HBOS Reading of 28th of February 2020, and the crimes that are listed on there with the jail sentences are, we have fraudulent trading, contrary to section 458 of the Companies Act 1985, 3.5 years imprisonment. We have conspiracy to conceal criminal property, which is proceeds of crime, contrary to section 1 of the Criminal Law Act, 3.5 years imprisonment. We have conspiracy to corrupt, 6 years imprisonment. And we have one is conspiracy, sorry, we've got conspiracy to conceal, and then the concealment of criminal property, we've got 6 years imprisonment. So those are the 4 criminal charges we need to prove in civil proceedings to invoke the criminal jurisdiction under the Criminal Law Act 1967, section 4, that if you are witness a crime, you stay silent, then you're a criminal, basically. So now I'm going to move to the Leighton and v. Bristow and Souter judgment. And in that, I'm going to basically give the case number references J90 Sierra Alpha SA 002. This is dated the 20th of September 2023, and this is regarding the fraudulent enforcement of liability orders without exercising the rights, statutory rights of appeals, whereby the files are not retained in the magistrates' courts and the bailiffs are coming at the door without serving a valid instrument that can be appealed by using fraudulent instruments, and that proves fraudulent trading against the councils for issuing bulk liability orders. So, and that also applies with service charges. So Lee, yours is a service charge case in a civil court that has been litigated 4 times, and that comes under res judicata. And the council has not provided you the services that it's charging you for, whereas you've been injured, you've been kidnapped, you've been denied oxygen because you've got scaffolding over your windows, and your council is asking for service charges that were not part of any valid contract. So do you want to elaborate on anything I've said, Lee, about how you're going to do this? How are you going to change your civil jurisdiction to the criminal jurisdiction now?
I'm not sure of the exact procedure, but it would be by issuing a notice on all parties. And
well, the point is that you've got the Leighton judgment, you've got the Lloyd's judgment. I was hoping you were going to use the precedents of those cases of the criminal jurisdiction. So if I go to the confiscation of proceeds of crime after conviction, okay, because the councils usually don't get convicted, criminally convicted, because they seem to have some kind of privileges. but they seem to be able to continue to issue liability orders despite the High Court judge in Leighton saying they can't do that. So the problem is, Lee, that the criminal jurisdiction is not a request, it's a mandate. When the council has hired outside lawyers who've litigated the same issue 4 times against you, and it's called res judicata, and it's public money that's being laundered. That's what we've been discussing, is the councils are laundering the proceeds of crime because these liability orders have been proved in the High Court to be extorted through, without following proper procedures of the rights of appeal being offered to us. So anyway, the confiscation, this report, it is up to us how we apply this report, because they can't say that this is to do with speeding up the payment of damages for victims of crime. So would you say that you're a victim of crime because you've been kidnapped without being provided your right of appeal, and you've now been put through the courts 4 times for service charges that they have not proved a valid contract, they've not produced it? And so are you able, we're talking generally, because the Criminal Law Act 1967, Section 4, actually permits us to discuss this criminal jurisdiction within your case. And that's what we're talking about, is transferring from civil to criminal. And once you use that law as the transfer, it cannot be denied by the civil court, because we are saying you have evidence that you were kidnapped without being served with paperwork to deny you your right of appeal. Is that correct?
It is correct. And the way that they can fiddle the system is by claiming immunity as the local government, that they can ignore the High Court rulings by privilege, parliamentary privilege, and that they claim they cannot be prosecuted for their crimes, that they can hide behind the veils of immunity. But it's abuse. They're actually abusing their immunity privilege, which is given to them by Parliament. And because they've done it so many thousands of times, as you quite rightly state, you know, they're issuing these liability orders on millions of people, which is a crime, then they're saying they can do that. They can commit as many crimes as they want to, because they are the government and they have parliamentary privilege and they can get away with it. In other words, they're saying, what they're claiming is that they are the mafia, you know, gangsters and thugs, and they can get away with being criminals because they control the law. They make the law. They are the government. And there's nobody higher than them. There's nobody above them who has authority. Probably only the monarch may have some authority that can be exercised, and maybe the monarch can withdraw their privilege away from them, because Queen Elizabeth actually, she actually handed over or passed her privilege onto Parliament. She gave it to them so that they could, to the ministers, who can exercise her royal, you know, her royal prerogative on her behalf. But they're abusing it. They're not doing it. They're not. It would be good if they exercise it justly and fairly and honestly, but they're not. They're being dishonest, and they're making dishonest profits, and they're you know, it's a very big subject. You could go on and on for hours about this subject. But yeah, I over to you.
Yeah, so I'm going down the this confiscations report by the Law Commission. I'm searching the term criminal law, and it's quoted the Criminal Law Act of 1977, which I'm sure runs parallel with the 67. I hope it makes the silence a crime. I just hope that if, you know, the government is using concealment of crimes in civil courts, then they need to be made aware that local governments are not really looking at the precedents of Lloyd's and Leighton, which puts a mandate on them to cease and desist the fraudulent trading they're doing with the bulk liability orders. They're still enforcing your service charges, even though the Leighton judgment made it basically it's a crime. It's a crime of terrorism if you're being denied your right of appeal in a democracy. So you can't call England a democracy if you're being enforced with fraudulent documents without you having your exercising your right of appeal. So you've had that done multiple times against you and me too. And so we're entitled to our damages. I'm just going down this report, and it's talking about the language to use in criminal law when you're dealing with confiscations. And so I'm going to basically let people go through this report by themselves. It's free of charge and it's online. You can get hold of it. Just type in Law Commission report on confiscations and it comes up. This is the final report, which is 642 pages long. And so it's got concurrent proposal 6, concurrent confiscation, enforcement and financial remedy proceedings. What we're saying is that if the councils can enforce liability orders against us without following proper procedures and by denying us our rights of appeal, then when the bank, the Lloyds Bank bankers were jailed for 49 years, then the Lloyds Bank should have been subject of confiscations to pay the damages to the victims. That we're drawing parallels between what they do against us, which is not follow proper procedures, and then what they do when it's a bank involved or local government involved. The local governments are continuing to enforce liability orders in bulk, denying rights of appeal. I'm just drawing a simple analogy, Lee. So what do you want to say about that?
That is correct. Yeah, you're expressing it very well. Yeah. And they are enforcing unappealed liability orders by property charges against hundreds of thousands of people, which is terrorism because they've blocked the right of appeal, and that can only be terrorism. And the proof is obvious. And yeah, over to you.
Yeah, so I think that's a good place to stop, Lee. I think we've given enough material for people to do their own research about so how do you redesign your case from a civil court to a criminal court. Then the other thing is you have to find a court with a resident judge that is on the official list of resident judges at the judiciary.uk website rather than gov.uk or HMCTS. So there are many business centres that are pretending to be courts, but if they don't have a resident judge, then they're not an official court. So I'm just going down the list of resident judges, Lee, and I'm looking at the Crown Courts. So the Crown Courts I have that are official, there are 36 of them. Got Birmingham, Leicester, Lincoln, Nottingham, Shrewsbury, Durham, York, Chester, Manchester again in Minshull Street, Preston, Aylesbury, Cambridge, Chelmsford, Croydon, Guildford, Harrow, Inner London Crown Court.
It would be the Inner London Court, yeah.
Crown Court.
What street is that in?
It doesn't say, but the resident judge is Her Honour Judge Usha Karu, Luton, Reading, Snaresbrook, Southwark, St Albans, Wood Green, on Woolwich, Bournemouth, Bristol, Gloucester, Plymouth Combined Court Centre, Truro Crown Court, Taunton, Cardiff, Mould and Swansea. That's the 36 Crown Courts. So that's where we would go to transfer our civil jurisdiction. And then we could, if that's refused, then we could issue a summons with the SP001. I'll just pull up that form. So the summons form is called SP001, which you normally submit in the Magistrates Court. But because we are going to go straight to the Crown Court because of the precedents of the criminal jurisdiction of the Criminal Appeals Court and the High Court of Lloyds and Leighton, then we're using this one, these procedures and these forms. If the county court judge refuses it, she has to give you the refusal in an order that you can appeal to the Crown Court, or you can just go straight to the Crown Court because of the precedents. It's up to you. Okay, that's all. Thanks, Lee.